Administration. Hi, I'm Yvonne from How and Hospera.
And I am Karamjit from How and Hospera.
When a person dies, his asset must be disposed of. The law of succession determines how these assets are to be disposed of. Now the statute relates to will is called the Wills Act 1959.
The purpose of a will is to enable a person to dispose of his property as he wishes after his death, to create interests and appoint executors to collect, manage and distribute the estate, to appoint guardians for the children and to inform the beneficiary of how he wants his funeral to be. A will is a declaration of a person's intention and may be freely revoked or amended in a prescribed manner when the person is still alive. However, when he or she passed away, the will crystallizes and takes effect according to the contents stated therein.
You can only leave one will. Therefore, your will has to be valid. Let's look at the elements of will.
The elements are: you must be at least 18 years old, sound mind, it must be in writing, it must be signed by you in the presence of at least 2 witnesses who will then sign in front of you and each other. Beneficiary of a will cannot be a witness to the will. The benefits of wills are: you can decide how to distribute your assets, you can choose the executor of your will, you can avoid the unnecessary fight between the beneficiaries. The executor stated in your will can apply for grant of probate, which is cheaper and straightforward.
If you die with a will, the executor will have to apply for a grant of probate in order to administer your estate. It is a court order that gives the executor the power to touch your estate and to run it in accordance to your will.
The cause papers filed in the High Court includes originating summons, affidavit in support by the executor exhibiting the death certificate, will, list of assets and list of beneficiaries, administers oath, notice of appointment of solicitors, affidavit of witness of the will. It is simple, cheap and save time.
If you die without leaving a will, any persons interested in your estate can apply for a letter of administration from the High Court. Upon the making of an order for the grant of letter of administration by the High Court, the assets of the deceased will vest in the administrator, who will then distribute the assets of the deceased according to the Distribution Act 1958, which sets out the persons entitled to the estate and the manner of distribution.
On the hearing date, the applicant has to be present and bring his IC and death certificate. The court will check whether Form C in the system is white or yellow. It is not a complicated process, but it requires more time, more cost paper to be prepared and filed, and it is also slightly more expensive than probate.
Will is important, but you can draft it yourself. It does not need to be drafted by a lawyer. However, to ensure that your will is valid, it is advisable to consult us to draft a will today, to avoid any unnecessary trouble in the future and to save costs as well. That's all for today. I'm Yvonne from How and Hospera.
I am Karamjit from How and Hospera. Thanks for watching.